All right, what's up, folks? Okay, so jury selection underway in the Karen retrial. Jury selection underway in Lori Vallow Daybell's case. It appears Lori. Shout out to Lori. Lori might actually be. I think trial's actually going to start sooner than anticipated. It sounds, if I remember correctly, I believe they might be good to go on what day is it today? Tuesday, is today Tuesday? I'm confused. I think they might be good to go on Thursday. As for Karen Reed, though, Karen Reed, I had always questioned how they could potentially, possibly end up with a neutral jury in the Karen Reed trial, but so far, two jurors are seated. Okay, two two individuals are seated. They start off with a new group tomorrow, and then let's see. Again, I suppose it's good for the defense because, from my perspective, um, that must be the main reason why they were doing all those interviews. What's up, Benji? Benji, did you watch? I mean, there's not really much to watch today, but did you watch jury selection in the Karen retrial or not? Okay. So, as far as the jury pool is concerned, okay, so 78 folks knew or they talked about the case. 78 individuals. 40 expressed that they had formed an opinion, and then obviously 16 indicated that they had a bias for or against Karen Reed. And then 36 had to be excused because they'd suffer severe hardships if they were required to serve on the jury. But 16 individuals, pretty much their minds were made up. 16 individuals, their minds were made up. And I've said this before. That must have been a defense strategy for them to, have all these press and media runs, because obviously they don't have. If they cannot find an impartial jury, then it not only does it prolong things, but they might be hoping that somebody that's actually for Karen Reed slips onto the jury, and in the end it ends up being hung like the first time. Okay, so Benji said, no, I didn't. I've been watching movies and eating ice cream. Okay, what did you watch? And are you off? Are you off today? I watch a lot of Judge. Shoot, I forgot I was supposed to comment on his videos. I watched a lot of Judge McBurney today. There was a pro se in Judge McBurney's courtroom today, Uh, and he might actually be more than a pro se. He appeared to me. He sounded like he was one of these sovereign citizens. And if you've ever watched any court proceedings, or if you've ever been in a courtroom with a sovereign citizen, you're in for a show. So yeah, very, very interesting stuff. Let's see. So Benji's off today. Watched John Carpenter's The Thing. Okay, well, I'm glad that you're spending your day off with me. All right, let's quickly get into Lori Vallow Daybell. Let me see. Did I caption this? Okay, I did caption this properly because I was trying to figure out what the title of this video is. Let's quickly start. We'll start with Lori, and then we'll move to the jury questionnaire, because we did not get to the jury questionnaire last night. I don't know that we can get through all of it, but we'll try. So let's see. I hear there are fireworks, so that's what
with
we need.
OPDS right now, and they should be being issued currently.
Dang, shout out to Lori. She has a suit on and everything.
The state talks about in their response, like,
Okay, and here's the thing. The thing about the sovereign citizen, let me go back on Judge McBurney's video, not video, his channel. I just want to see. I don't want to get locked up, that's for sure. I don't want to get locked up. But no, I'm going to do this. I'll call the courtroom tomorrow. That sovereign citizen is not going anywhere. I'm gonna find out his name, and when he goes to court again, I'm literally going to be following that man, because he kept asking the judge, is this a criminal court or is it a civil court? I don't know. It was a lot going on. Anyways, let's get into Lori.
The state
I
is
know.
claiming
Hopefully Brooklyn comes up here, because I think Brooklyn he may have watched it.
trial by ambush from the defense. Trial by ambush. How is the defense trial by ambush?
Yeah, the sovereign citizen, I think his name was Mr. Pierce. He was citing case law. I mean, he was citing it incorrectly, but he had case law. You guys know I'm impressed by people that come with authority, okay? He was very interesting.
When they have interviewed every single one of these witnesses before in the last 5 years since this case started, they've interviewed every single person that has been on there. They have written, transcripted interviews and video interviews of all of these people. And so how they are relevant, these witnesses will testify if and when they are needed to add additional facts or fill in the blanks that the state will no doubt leave out in their case in chief, and they'll be called accordingly. I need them to lay perhaps foundations for evidence presented by the state. The same with Lonnie Dorkin. I need his testimony will be required if and when it's necessary to rebut digital information that the state will bring forward during trial. I feel like the state is trying to say, okay, if you want your speedy trial, guess what? We're not going to let you defend yourself. Guess what? You can't have any experts. And guess what else? You can't have any witnesses. You can't have anybody speak in your behalf. So
look at my new bag. What's up, old bag? Old bag. No, I don't know. Saggy pancakes. I don't know. What's up, though? I missed you.
Good luck. Have a nice day.
All right. Well,
wait, what?
Speaking, you have any experts. And guess what else? You can't have any witnesses. You can't have anybody speak in your behalf. So good luck. Have a nice day.
Lori should have hired an attorney, even a public defender, somebody.
All right. Well, that's why attorneys sometimes take a long time to prepare for a trial, because they need to give notice of what all the testimony their witnesses are going to give. They need their experts to prepare reports. Okay. That's why your prior attorneys and your current attorneys were asking for more time to prepare the case. So you can't really have it both ways, that you want your speedy trial rights, but you don't want to give notice to the other side of
Lori should have gotten an attorney.
What
I mean, you did have one.
I don't not want to give notice to the other side, with the limitations at the incarcerated state where I am, and the limitations with OPDS of getting Lonnie Dorkin late in the game that they did. I've done everything in my power as a defendant to prepare the state, and to give over everything that I could do within my power, with the limitations that I am an incarcerated person at this maximum security prison jail.
So when you say,
and I shouldn't be able to represent myself because of that fact, that negates my constitutional right.
Dang, say that. All right. I said that sometimes there are reasons to not go forward to trial as fast as you want. All right. So when you say things like they're going to fill in the blanks, that makes it really hard to assess what their relevant information is.
They have relevant information to a lot of factors that I got in the 404B information. For example, the life insurance. My father is a life insurance salesman. He worked with Charles on getting both life insurance policies, my $2 million policy and Charles' $1 million policy. He also tried to sell my insurance policy.
Oh, bag, you could have emailed me. I mean, it does take me a while. Takes me a while to respond sometimes, but I would have appreciated your email. Okay. Old bag thinks the judge in Lori's case is too soft. I'm sorry. Okay. I don't know that he's too soft. I think it is proper. I like his demeanor. Okay. I like his demeanor. And the reason for that is because Lori is unrepresented. And in the event of an appeal, they're going to overly scrutinize the judge. That's obviously if she gets convicted. Lori probably is getting convicted. But in the event that she is convicted and there's an appeal, The appellate court is definitely going to overly scrutinize the judge, which would not have been the case had Lori been represented.
Charles passed away. He also told me to go to call the insurance policy and said how to do that, how to call them when you're the beneficiary. I didn't know how to do any of those things. He has relevant information to that. My sister has relevant information to my brother, Alex Cox, and the whole situation of what happened on July 11th. These people have relevant information to the state's case, what they're accusing me of. There's very relevant information from a lot of these witnesses.
Okay.
So what I'm struggling with is you just saying that it's relevant doesn't actually make it relevant. It may be relevant. I'm trying to find out the relevancy. What you said about your father being an insurance salesman and selling policies, that sounds relevant. It could be relevant to me. Who's your father? I don't know who your father is.
Barry Cox.
All right, Barry Cox. It sounds like even from what you're saying, though, you're not, depending on what the state produces at trial, you're not sure that these witnesses would have relevant information. It just depends, is what it sounds like.
Whatever they put up in their case in chief, am I not allowed to try to defend myself against that?
Lori.
You're absolutely allowed. I'm just trying to figure out, I'm sort of a gatekeeper and I need to make sure witnesses have relevant information.
Right.
And just like you have the right to interview all of the state's witnesses, excluding victims' rights, people that can deny having an interview, they have the right to
I missed your input, old bag.
interview all your witnesses prior to trial so they can have an idea of what those witnesses might say on the witness stand.
I understand that, Your Honor.
So
they also have already interviewed all of them.
I'm not talking about police interviews or interviews that may have been done years ago. The prosecutor has the right to interview any witness prior to them taking the stand, just as you do. So I'm not sure the best way to handle this other than maybe we should take it up as we progress through the case, but
Your Honor,
some of these people may or may not be even served.
Yeah, my concern is obviously I have attempted to reach these people. I've made my good faith effort. I've been told both by myself and attempting to contact them, as well as the defense investigator, that they've been unable to reach them. So it seems to not be following the rules of procedure or evidence to then bring up later on if they perhaps find these people at some point, then the state can try to at that point preclude them. When the state talks about a trial by ambush, it is in fact that. When the defense investigator themselves cannot find these people and are still looking for them in trial.
Shout out to Lori, man.
When they've had at least, we'll say, 4 months to try to find them. I think that at this point, precluding them is proper.
Well, I would preclude anyone that doesn't submit to an interview with the state. I kind of want to punt this a little bit just because if there's people that don't end up getting served, don't end up showing up at court, they can't find, then we don't need to waste our time talking about whether or not those people have relevant information because they're not going to be here and they're not going to testify. So I'm putting the defendant on notice that if these witnesses aren't served, if they don't submit to interviews.
I'm just out here talking. Something happened to my mic. I was out here talking. It turns out my mic was muted the whole time. Old bag said, yeah, Lori might have gotten some hair dye. It looks blonder. That's even a word. Old bag said it's kind of weird. We're getting the back of the head view. Yeah, I don't know why that's the angle. Maybe, obviously, I don't know. I was going to say something about the jury, but the jury's not seated yet. So I don't know. I don't know why we're looking at, the back of her head.
They're going to be precluded. even if they submit to interviews, I may have to make a determination
All your bangs.
whether their testimony is relevant or not. So again, we're going to, I think, have to cross that bridge when it comes. The state did say that they concede that some of the witnesses, Adam Cox, Janice Cox, Summer Shiflett, may have some minimally relevant information.
All right.
The rest of these, I think we're gonna have to take up maybe on a piecemeal basis, but I don't want it. It's not gonna be a situation where you're ready to call them in as a witness the morning of, and then the state they haven't been presented to the state for an interview prior to that. So keep that in mind when coordinating with your investigator. If he gets them served and they're actually going to be called at trial, they need to submit to an interview in advance of their testimony.
Your Honor, I understand that, and I am limited in what I can do. If I could call these people myself, they would answer my call probably, and I could have this discussion with them, but I'm going through the limitations that I have at the jail through my paralegal who's working overtime and my investigator who's working overtime to try to do everything to help me prepare for trial, as they have other clients as well that they have to do things in a timely manner for. So.
Okay, once we get through, Lori, we're going to take a look at those jury instructions in the Karen Reed trial.
We are doing the best that we can.
Okay. All right. If you have an
Is
attorney
the judge okay? I don't know that the judge is okay. I don't know that the judge
in Idaho that is working on
He's kind of, he has labored breathing, kind of like Bev, but not quite like Bev.
an appeal, it appears that the information that was turned over by the jail was some pretty innocuous messages about trying to set up the legal line to talk to you on a confidential line. And really that's about it. So how does this arise to some sort of nefarious interception of things? Because it was put on a public chat system that the jail uses. You know it's not confidential. And you're told it's not confidential. And then even if I look at the substance of the messages, there's really nothing in the messages that would arise to some sort of confidential communication, just trying to set up a meeting and get the unrecorded legal line set up.
Who's saying that they're not confidential?
Well, the
Who's
jail,
telling me that they're not confidential?
your own attorney, it looks like. Here's a message.
Dang, Lori.
I see that they came and got you. I'm working on getting a confidential attorney line set up. The implication being that this message is not confidential. The next one, again, just checking in. Hope things are getting a little better for you. I'm still working on getting a legal line set up. The implication is that these are not confidential.
Okay, so then he received a letter from MCSO that said your phone number is now confidential and arranged for privilege.
Lori's jury selection began today. Yep. Jury selection began today. I believe if this information is accurate, they should be good to go. At least the judge projected that they might only need one more day of jury selection. So I'm thinking they probably get started tomorrow or the day after.
Confidential client privilege communications. So
Phone
from
calls.
No, it says this phone number is connected to that. So from my perspective, when I call someone on the tablet or when I text someone on the tablet, it goes to their phone number. So all the communications after the date of the exhibit that we put in our motion, when he got that letter from MCSO that now all of your things will be confidential.
Okay.
Now they will be confidential. So my understanding, and I'm the only one that can waive that privilege, right?
And I think after that, when his line was approved, there were no other disclosures of messages between you and him, correct?
No, there are.
you received other disclosures of intercepting messages between you and him?
So those go up to the 24th of January.
No, the only thing I saw was up to, I think, late December of 23.
Okay, so there are confidential things that are in our communications because I was not aware that after he received that there were not. So the prosecutor,
Is Lori is Lori saying that the communications were not confidential, or that they were confidential because she was not aware that they weren't confidential? That sounds like what Lori said. Lori, you should have gone with an attorney. Okay, I don't know what your attorneys were telling you. Maybe the attorneys, this is me purely speculating, but because Lori is already serving life sentences, maybe the folks were like, Lori, you might as well just, accept a plea and keep it going. And Lori's like, no. Or maybe there was a disagreement about how to, who to call and how to present this case.
who obtained these.
I mean, I can find those answers. I can look it up.
Her protocol would not be to stop and ask the court for some guidance on this, maybe do an in-camera review if she's subjecting herself to
I think Lori is saying that the communications while she was incarcerated were confidential because she did not know that they were going to be turned over, or she did not know that they're not confidential. That's what it sounds like to me.
Privileged communications, instead of reading them and finding out and assessing for herself if there are anything in there that's confidential information between me and my appeals attorney. I have no other way to communicate with him when I'm in this incarcerated situation because I was brought here to Arizona to deal with these charges. So
where do you want to be, Lori?
It is a problem. It's a problem that she took them. It's a problem that she got them from MCSO. It's a problem that she read through them. It's a huge problem that she put some of them into her motion, and now his IP address is exposed to the public, which is a federal offense. There's a lot of things wrong with what has happened here.
Well, you reminded me that when his number was approved, he then sent messages from different IP addresses instead of that phone number that was privileged. So he's the one that disclosed or related confidential nature. I don't see that any of these, I'm going to call them inadvertently intercepted messages between you and your appeal attorney. I don't see that they're being used in any way by the state.
Just the state reading them as a violation of the client-attorney privilege.
Well, not if they're not done through a privileged setup the way that they were supposed to, which he even acknowledged.
My understanding from my perspective was that that phone number was now privileged. The way it comes to me on the tablet is I text that phone number or I call that phone number.
Correct.
So,
if you're communicating through the phone number, but if he has it set up where the messages aren't being sent and received actually through the phone number, but through different IP addresses, they wouldn't, the system doesn't know that they're privileged because they're not being sent and received through that privileged number.
But I didn't know that. There's no way for me to know that from where I am in my cell. There's no understanding for that. I assumed he was just getting them on his same phone that we were having client attorney privileged communications. And is the state giving these to Idaho? Do these get dispersed out? I would like to know that. Where are these going? They're getting them.
Yeah, I just had to look up some stuff here because I enjoy, you guys know that I enjoy Judge McBurney's courtroom. Okay. So I'm going to have to find a way, because I enjoy it so much. When I do have time, I'm going to ask for permission to actually, rebroadcast some of his stuff up here. Because they removed the disclaimer, but I had to listen. I don't want no problems. I don't go out creating problems for myself. But in the background, I was double checking just reconfirming, but it's definitely not permitted. But when you guys do have time, I'm gonna find the timestamp. Okay, I'm gonna find the timestamp, and you guys can go actually watch the live stream. But there was a sovereign citizen in Judge McBurney's courtroom today, and it's probably the best thing I've actually seen all day. It was great. It was great. He has prior to this, Lori was my girl, okay? Because I'm like, Lori came with case law. But Mr. Pierce, if that's his name, is very interesting.
MCSO. Is there a subpoena to get these from MCSO? Is there a warrant to get these from MCSO? I didn't see anything.
Yeah, Lori, I don't know, Lori. Lori should have, I mean, she did have an attorney though. Can she? I don't know. It's kind of too late to ask for a continuance. Lori.
That warrants them getting them from MCSO in the first place.
All right, let me hear from the state.
And I think that the state's motion really covers the law under this. The defendant and her attorney were provided with information, whether or not she understood it or not. Her attorney understood that it was phone calls that were covered. So it's not just the defendant who is not complying with following the correct procedure to utilize the set up attorney-client privilege means
I know I talk slow, but she talks real slow
to communicate.
I know once Benji came up here saying that I actually put him to sleep sometimes.
In this case, the state, obviously, I disclose those before I even look at them. I
Yeah, you're
understand that
gonna have to listen. Benji, Obed, you guys will have to watch. I'll get the timestamp. You don't have to watch all the proceedings from today because it was like, I don't know, over 7 hours. But when Mr. Pierce, if that's his name, when he got up there, it was real fiery. It was fiery.
that they are statements by a defendant, and I believe that they are to be disclosed under Rule 15. And so before I even look at them, I send them to the
Oh,
defendant.
really?
Because I don't have the option of
What's it called? I'll take a look at it.
not providing them to her since they have been obtained. I think if you apply the case law in this, the
I mean,
defendant
obviously, we're not going to bug the kid, but I'm interested in finding out what it's about.
cannot meet her burden to show that there's any legal advice in these messages. There's no privilege in them. The messages are asking to set up times to call and to speak.
And going back to Judge McBurney, there was a case on there. It was an R case. R, you guys know what that stands for. It was an R case. The defendant was accused of R-ing his own cousin. I'm like, what the hell? This was for 4 years ago. That's when it allegedly occurred. As far as actual, I'm trying to figure out if this case is linked to the backlog that we discussed last week, but I don't know. It was yeah. It's, if that case goes to trial, maybe it's not probably not going to go to trial this year because if I'm not mistaken, I believe his attorney just entered his appearance today, so it's going to be at least a year and a half, maybe 2.
Are the three, I think it's 3 messages that you included in your response, are those all the messages?
No, Your Honor, there are other messages, and we do say that tablet messages between Ms. Daybell and Mr. Jerem do not end on December 28th. They continue.
And there is privileged information on them going forward. And the state is basically testifying for my attorney now. She just testified for my.
Hold on. Lori said what?
December 28th. They continue.
And there is privileged information on them going forward. And the state is basically testifying for my attorney now. She just testified for my attorney that he understood that that these were not privileged communications. Where does she understand that where is she testifying for my attorney?
Well, I think because the context of the messages say I'm trying to schedule a
Lori,
time and I'm trying to set up a confidential line, meaning
That was
this is not
before.
confidential.
That's right. He said it wasn't confidential before MCSO gave him a letter saying your phone number is now confidential. Your phone number now has.
Okay, I'm not going to keep rehashing this with you. The fact that he's using different IP addresses and not messaging
it's
through
real,
the actual phone number that's protected, I think is part of the problem. So if he's not using the program correctly, that's an issue you need to take up with your attorney.
How is he using it incorrectly?
I just told you. He's not messaging through the phone number. He's using different IP
How
addresses.
can you message other than the phone number? I don't understand that.
I don't understand that either, but if it was from the phone number.
So Judge McBurney's courtroom today, okay? Go to Judge McBurney. The timestamp for that is 6:23:22, okay? 6:23:22. There are basically 50 minutes and 40 seconds left, okay? But 6:23:22, that's when I believe his name was Mr. Pierce. It's not that long. It was, I believe, I was working when I was watching or listening to this. It must have lasted about maybe 6 to 7 minutes, but it's definitely worth watching. Okay, 6:23:22. Okay, Old Bag has not watched it. Okay, so Kobe. Okay, 6:23:22. Okay, so I'll take a look at this now. All right.
And it's for his cell phone, for example, it would be the same.
Once you watch it, Old Bag, please send me an email. Send me an email. I'll only read it tomorrow, obviously, unless you send it tonight. But even if it's tonight, once I'm done with this, I'm closing this MacBook. But we need to have a real discussion about that sovereign citizen.
IP address for each communication. Okay. There's like 4 or 5 IP addresses.
Where are the IP addresses coming from?
Lauren.
They're given to you by the state?
They're right there listed on the messages.
I'm just saying, where are they obtaining those from?
From your attorney's messages to you?
From MCSO?
Yeah.
Did they get IP addresses for every single person of every single message communication on the text from MCSO?
Well, it's listed on the messages, so I assume so.
All right.
It says Craig Durham, and then under it is the IP address from the device that's being used.
Okay, and then Ms. K is reading all of these messages, and they're not privileged. Is that what you're coming to?
They're not privileged if you're not using the program or your attorney's not using the program correctly. Okay, they're still not going to be allowed to use any.
Let me see. I think I need to help Lori out. I think during my time, that's exactly what we're going to do. Obviously, I think that the Lori Daybell case, what's her name? Daybell? Vallow? Daybell? Okay, so Lori's case obviously is going to go before Karen Reed, okay? If Karen Reed has a seated jury within a week, I will be very, very surprised. And if they have a jury seated within a week, that might actually be, listen, I have questions. Let me put it that way. If Karen Reed has a so-called impartial jury seated within a week, nope. In any event, I'm getting distracted. So for Lori, when she goes to trial, I'm going to act as standby counsel. Okay, that's what I'm going to do. I'm going to help her ask better questions, and I'm going to help her make better arguments. That's, I mean, she cannot hear me. She cannot hear me. And besides, by the time that I actually watch, I don't know what time. Oh, but Arizona, that's 3 hours. I think that's a 3-hour time difference. So actually, by the time that I actually make it home, Lori might still be in court. But that's exactly the cross-examination. She's going to need a lot of help. Yeah, Lori's going to need a lot of help with cross-examination, but I'm here to help her.
Any of these messages. What I'm saying is they're inadvertent disclosure by MCSO because someone's not using the program correctly. Doesn't mean that they had bad faith in how they got them. They made.
How is he using it incorrectly?
Olbeg, when you're saying questions for the defense or the Commonwealth, Are you referring to me saying that I have questions if they have a jury seated within a week? I don't have necessarily, I didn't have questions for either side, but I highly doubt. Listen, if we take a look at the numbers, did I lose the screenshot? I gave out the numbers. I'm on my phone, but I have way too many open tabs. I should have taken a screenshot. Hold on. Let me see if I can pull that up again. Can I pull it up? Oh, here. So from today's jury pool, okay? I believe, if I remember correctly, they had 100 folks. They had 100 potential jurors in court today, okay? Out of those 100, 78 individuals knew or they talked about the case, okay? That's, I'm not good with numbers. As far as percentage, obviously that's 78%, but I was trying to fraction that out. I don't know. As far as fractions goes, that's a little over. That's a little over. No, that's actually under. It's gonna say 2/3, but that's kind of that's a huge chunk. Out of 100 individuals, and 78 folks already knew about the case or they've talked about their case. Definitely not good for the here's the thing though, because I was gonna say not good for the Commonwealth, but here's the reality. While a lot more people again, let me get my thoughts together. Okay, so 78 individuals knowing about the case or talking about the case, not good for the Commonwealth, because under these circumstances, the Commonwealth wants an impartial jury. Okay, that's what the Commonwealth is hoping for. They want jurors that will actually listen to the evidence and then reach a verdict. And obviously, they're hoping for a conviction. All right. As far as for the defense, the fact that 78 individuals knew about this case, it's good for the defense in the sense that they've accomplished their media run. Because from my perspective, the only reason that the defense was out there talking about this case, giving interviews, especially the local, the one we reacted to last week, I believe that was a local news station, right? And if it's on a local news station, it's much more likely that folks in that specific area of the state will actually be watching. Because didn't that interview air at night or something like prime time? In any event, so okay, the fact that 78 individuals from this jury pool watched the interview or have heard about the case, read about it in a paper or something along those lines, talked about it with their, their lovers and everybody else, the defense achieved or they accomplished their mission. Because from my perspective, defense would not, or at least to me, from a defense perspective, okay, defense is hoping to pretty much I don't want to say pollute's not the right word, but they would like to influence the jury pool, okay? And the reason for that is because if they can end up in a situation that is kind of similar to what's a kid's name? Y&W Melly case, where they had an individual seated on the jury. And from the very beginning, it is alleged that this individual was not going to convict. Okay. They did not, it sounded like that individual had a mission. All right. So that's what they're hoping for. But from my perspective as an attorney and somebody that has high regard for, the practice and somebody that actually wants to what is this watch a case, you guys know I don't like the mess. I don't like the mess. Is it entertaining sometimes? Sure. but overall, I am hoping to learn things that I probably otherwise would not have considered. In this case, I'm still really upset with Jackson because he engaged in improper conduct, and I don't like that. Okay, so moving on. Uh, the hope is an impartial jury. So, in a case that is as highly publicized as the Karen Reed trial or the Karen Reed case, if if they can have a seated jury within a week, I am going to lean more towards right off the bat. Usually, I don't form an opinion as to how a case is going to, and I mean, I already said Laurie was going to get convicted, but with this case, with this Karen Reed case, I have a projection. I think it's hung, but obviously things can change as we actually listen to the evidence, and I believe Hank is bringing on different, or at least his strategy is going to be very different from Lally. So we're yet to see that. And another reason where, hold on, because now I'm thinking about yesterday's ruling from Judge Canoni as well. But here's my point, though. I do not know, or I highly doubt that Karen Reed can have an impartial jury within a week. I just don't see it. I don't see it, and the reason I don't see it is because of the pre-trial publicity that this case has received. Um, yeah, so my questions are not necessarily for the Commonwealth or for the defense. It's just a phrase I use. I often say that I have questions, and when I say I have questions, is because I've formed certain thoughts or I have a certain opinion, and I'm just not verbalizing what that opinion is, but I've just verbalized that opinion. I do not know that they can have an impartial jury. I just don't know that they can have a jury seated within a week. If they do, then I think that signals more to folks that are most likely more favorable to Karen Reed and did not actually make that known during jury selection. But if we go back to this, what is this? The numbers that NBC is reporting. So 78 people knew or talked about the case. 40 expressed or formed an opinion. And that's still pretty high. Okay. And here's the thing. I still find it hard to believe that 78 individuals would have heard about this case or talked about this case, and 38 want us to believe that they did not form an opinion. That's, I don't buy that. I don't buy that. I don't buy that. And so 16 people are pretty much saying that they are biased for or against Karen Reed. That's still, out of 78, I still don't buy it. I think here's the thing. When it comes to jury selection, especially the questions, sorry, Lori, I'll get back to you in a moment. When it comes to jury selection, especially if folks are being questioned in a group, it's not everybody is forthcoming, because again, if we have to consider the question of whether they had a bias for or against a defendant, an ordinary, here's the thing, they aren't ordinary people, but I would be inclined to believe that a juror is less likely to answer that question truthfully if their identity is known. Okay. Yeah, they're much more, they're less likely to answer truthfully if the identity is known, because obviously it's not that obvious. But a question of this nature, a question that goes to bias, a lot of people, a lot of us, either we don't recognize that we have biases, or we do recognize that we have biases and we recognize that it is not a positive thing. And instead of just being forthcoming and saying, okay, I'm biased for or against Karen Reed, we're like, no, I've not expressed or formed an opinion, or I'm not, biased for or against. So, yeah. And then the 36 individuals were like, no, they'll, suffer severe hardship if they were forced, quote unquote, to be on this jury. But 78, that's a high number. Okay, and Old Bag loves the idea of me being standby counsel. I'm definitely gonna help her out. So, okay, yeah. Apparently, they seated two, a man and a woman. I do not know that that tells us anything. I know that actually. Let's take a look. Let's take a look because I'd like to know. I'd like to know the kinds of jobs they have. And the main reason I'm interested in that is as it relates to Proctor, okay? Because again, Proctor is a huge thorn for the prosecutor. Where Proctor's not going away, even if he jumped off a bridge overnight, okay? He's not going anywhere. His prior testimony still comes in, all right? His prior testimony is definitely going to come in. But let's listen to Ms. Daybell, and then let's find out what these jurors do for a living.
I don't know how else to explain it to you. I've told you 5 different times now. So he's not messaging with the phone number. He's messaging from different IP addresses.
Okay, can I ask if these messages are being
Yes.
disseminated anywhere to Idaho, to the prosecutors in Idaho? Because that's definitely affecting my appeal if that's the case.
I don't know.
Lori, if you have an appeal, why are you representing yourself? Why are you doing? Because that's the other concern I had with this trial, right? Because again, you go to trial, and a lot of times people do get convicted. But when you have an effective attorney, they can preserve a lot of issues for appeal, and that does make a difference. A few years down the line, whenever your appeal is heard. So, Lori, I don't know. Lori,
Not been sent to anyone other than the defendant, Your Honor.
All right.
Lori.
So there was some communications I find that were intercepted between Ms. Daybell and her attorney. The state's not to use those communications. They're not to
Yes.
disseminate those communications, but I do find that they weren't purposely sought out by the state. And that dismissal isn't the appropriate sanction if there is an appropriate sanction. It's ordered denying the motion to dismiss for violation of confidential communication.
All right.
All right, then we have defendant's motion to dismiss for prosecutorial misconduct dated March 21st. Let me get that. And the state's response. The motion to dismiss for prosecutorial misconduct was filed on March 21. The response, I don't see a date on the response, but I do have the response. Did you get that response?
Have it?
Ms. Daybell, did you get that response?
I did. Your Honor.
Anyway, so I'm out here trying to just figure out what, and maybe we don't get that information. I was trying to figure out what the seated jurors do for a living. Maybe that information does not get disclosed, or it gets disclosed once everybody's seated. In any event, reading here, apparently Reed's newest lawyer, Victoria George, who was an alternate juror during Reed's first trial, is helping with the jury selection process. That is the dumbest thing ever. Okay, that is the dumbest thing ever. Listen, had this attorney actually worked in criminal courts, I've had a lot of trials, and even for somebody that has a lot of trial experience. I'm not qualified to select, not to so much to select a jury, but I'm not qualified to serve as a jury consultant. There are people that actually do that for a profession, okay? But here's the thing, I'm probably even more qualified than she is because she's not, she has zero experience with criminal courts. So this is just, I don't know. I don't know. These courts, these high profile cases are definitely not for me. But let's see. Okay, Olbeg says that was fantastic insight. Thank you. I don't even know what you're referring to, but you're welcome because I do a lot of talking and rambling.
All right.
But here's their reasoning. Apparently, she knows what it feels like to be in the jury pool and how evidence landed. Listen, I've said this before. Had she actually deliberated, that makes a difference, but she did not deliberate. So she did not deliberate.
So your prior attorneys had, actually, let me back up. The state filed a motion back in, I think it was September of 2024, asking the court.
All right, so I don't see information about, I'm getting distracted. There's somebody by the name of Miller Gardner. They're investigating. I don't know. I need to get off this website. In any event, I don't see actual information about, or not so much identifying information, but information that could give us an insight as to, you know, who the seated jurors are and what they do. Again, because I'm interested. Here's the thing. Typically for jury selection, okay? Overall, for Karen Reed, it's a little different, okay? And it's not just Karen Reed alone. I'm going to distinguish between cases where a defense is going to win. Ooh, actually, here's the case. The case that we can make a distinction. Let's go with what's the kid out of Florida? Think. Colin Griffith. Okay, we're going to distinguish between Colin Griffith. Let me think of another case, another recent case. I guess let's just go with Karen Reed because that's all I have in mind. Okay. So let me just think. Let me think a moment. Give me 2 seconds. Trying to think of any other recent cases where actually let's go with Lori. Lori's the perfect individual here. All right. So the Karen, not the Karen Griffith, the Colin Griffith case, if you guys remember, that is the kid out of Georgia, not Georgia, out of Florida. The allegations were that he, you know, offed his mother. The jurors did not know that, the jurors knew that he had offed somebody in Oklahoma, but a lot of that was redacted in the sense that he did not know the identity of this individual and that Colin was related to the individual. Okay. So if we go with Lori, I guess what they're going to, will they? I don't know. I did not look at maybe it comes out. Maybe it comes out during the trial. I do not know if the jury will be, I don't know that they, no. There's no way under these circumstances, unless Lori's just not doing a good job. But the prosecution should not be allowed to introduce her prior, unless if she gets on the stand. Lori, don't get on the stand, okay? Stand by counsel. I'm advising you not to get on the stand. But as far as Lori's case is concerned, a defense in this case definitely do not want information to be disclosed that she is currently serving life sentences and that she offed her own children, or that she was convicted for offing her own children. But here's the thing. if we take a look at, I still don't know, what does Lori have a defense? I know I need to take a closer look at Lori, because she's gonna need my help. Okay, but let's talk about the types of, or at least when it comes to jury selection, the two main approaches to jury selection. Okay, in the um, in the Colin Griffith case, the prosecution in that case, definitely, I think the prosecution in all cases, in most cases, 100%, 99% of cases, the prosecution wants jurors that listen to the law, jurors that follow the law. So under those circumstances, the main focus is more so on individuals that have some type of formal education. You pretty much want folks that would be focused on the elements, right? Whereas there's certain circumstances where the defense actually wants jurors that follow the law. And that's where the Colin Griffith case comes in, okay? Because in the Colin Griffith case, if you are just focused as a potential juror or as a juror, if the jurors were just focused on the underlying facts and the prosecution's case and the way they presented the case and the evidence that was elicited, then under those circumstances, the defense in the Colin Griffith case also wanted a jury that listens, or jurors that actually listen to the law. And the reason for that is because the defense in the Colin Griffith case was the stand your ground law, okay? And you don't get to that acquittal without actually listening to the evidence and listening to the jury instructions and applying the jury instructions as they are, okay? So again, there are two main approaches. Sometimes, or most times, all times, the prosecution want people that will follow the law to a T. Okay, and the defense does not always want that. Sometimes defense actually wants people that, um, you know, they want people that they can appeal to emotionally, oftentimes, okay? But in the Colin Griffith case, that is not what the defense wanted. The defense wanted people that will actually listen to the law, okay? But there's also a different approach. The different approach is sometimes, or most times, defense attorneys want individuals that are going to be a bit more relaxed in following the law, if that makes sense. And here's the reason for that. The reason for that in this, Karen, and again, this was me focused. I mean, a lot of times one would assume that um, people with professional jobs are much more likely. It also depends on the kind of and you could be a professional dancer. Shout out to all the strippers. So it kind of depends on what the profession is, right? For somebody like me, I'm an attorney, so I'm more focused on the elements and the rules. Whereas somebody like my man, he is an engineer, so that's, I mean, he's focused on different data. Okay, he's focused on I don't know about, I'm trying to think, I'm just trying to think of how we analyze and discuss certain cases. I'm probably more soft than he is, so he's probably more of a rule follower um, than I am. But in this Karen Reed case, though, the defense does not want, it's not rule followers, is not favorable to the defense. The defense needs an emotional appeal, okay? And that's why they were doing all these media runs and all that other stuff. And I guess paying off experts and not disclose that. To me, that still boggles my mind. That is the dumbest thing ever. In a profession where you're allowed to hire experts that favor your case, that is the dumbest thing ever. Yeah, I'm not gonna get over that. I'm not gonna get over that. But in any event, going back to Karen Reed, they definitely want people with an emotional appeal. And let me just quickly refer to the YSL trial, just talk about the YSL trial a little bit, but not all of it. Let's go back to the last two that were standing, okay? In that last trial, the last two that were standing, we had, shout out to Mr. Bumpus, and we had Yak Gotti, all right? So in that YSL trial, you had, this case definitely had rule followers, okay? By this case, I mean the jurors in that case were rule followers. And again, the what makes me believe that is because of the, what is this, the Taisha conviction, okay? When Taisha testified, I told you guys, when Taisha testified, when she got out there, she said, that is my man, I call him Bay. He was in the studio. He was in the studio of making a song about me. What else did she say? And her basically not knowing if they still go together or if they don't go together, whatever it was. When she got up there and testified, everybody else was saying, "Oh, she stood 10 toes down. She's a real one. She's this, she's that." And I'm like, that girl's testimony is incriminating. Okay, and obviously, right, and she's the prettiest girl. She's the prettiest girl that he's ever dated. Okay, so old bag is so funny. So after she testified, people were like, no, blah, blah, blah. She is this, she's that. She's a real one. And I'm like, that's incriminating evidence. And the jury came back and they said, yes, that's incriminating evidence. And that's why we're convicting on this. So that, as much as the jury process took over a year of their lives, because that's really what it did, um, they did not fall for the emotional appeal that what was Yagati's attorney's name again? Whatever his name was, Weinstein. They did not fall for the Weinstein appeal. They looked at the facts, and it was very obvious that once they removed Jeffrey Williams from the trial, there was nothing tying. There was absolutely nothing tying Yagati to, you know, the guns and drugs and everything else. So those were rule followers. Had the evidence been otherwise, and here's the thing: had Jeffrey Williams still been on trial, had he actually gone all the way, I mean, I will probably still be here. If we're being honest, we probably would still be talking about that trial right now, and it would still be ongoing. But had Jeffrey Williams remained on trial, that man was going to get convicted. There was no way around it. So anyways, to sum it up, defense really looking more for an emotional appeal, whereas, and that's only sometimes, because again, it depends on the facts, it depends on the underlying facts and the what you're hoping for jury instructions, as well as what the law is that's governing the charges. Okay, I was gonna talk a little bit more about, let's see, hold on, let me gather my thoughts. Okay, so going back to the Karen retrial. The Karen retrial, what they're really hoping, and again, we don't exactly know how different the presentation of the evidence is going to be, but as somebody that is mostly a rule follower, and I'm a rule follower because I've done both prosecution and defense, and I have to look at the evidence objectively. Okay. If during my time as a public defender, if I looked at the evidence here and I saw some stuff, I'm like, you're probably getting convicted, but we can go to trial. If that's what you want, let's go to trial. But even during my time as a prosecutor, I'd look at what I have, and I always found the loopholes. Listen, for every criminal case, even civil cases, but civil cases, the loopholes really do not matter as much. And the reason for that is because the burden is much lower. And a lot of it can often be be cured. I'll give an example right now, but I don't want to lose my train of thought. So even during my time as a prosecutor, when evidence was presented to me, I looked at the evidence and I'd point out to whoever the victim was. Basically, if the defense discovers this, this is going to be an acquittal. Okay. So under having established that I'm somewhat of a rule follower, depending on what the rules are, right? As far as this jury selection again, there are times when an individual's level of education and the types of jobs that they have would signal whether they are prepared to actually listen to the judge, listen to the evidence prior to forming an opinion and actually being guided by the evidence. That's what happens most of the times. That's not always the case. And again, depending on people's life experiences, they're just certain things where they're just not going to follow rules. Okay, if you put me on a death penalty case, I don't care how heinous the crime is. I'm not. It's not happening. The death penalty does not fly with me. We've talked about it over and over again. I'm just not going for it. Okay. So Olbeck says to me, I can't see how John was killed by a car. The difference is here. Here's the difference. Again, going back to, I'll get into this a little bit, but I actually took a screenshot. Let me see if I can find it because I have a lot of, I'm kind of over talking. How long? I've been up here a long time. I need to be gone at 10. But let me take a screenshot. Not a take. I need to read the screenshot. If I can find it, because I take a lot of screenshots, you guys. I take a I was gonna I heard something really crazy. I'll say it at the very end. I just looked up one of my screenshots. But there has been a shift in Karen Reed's or at least I've seen a shift in Karen Reed supporters. The first time when this trial was ongoing, there were a lot more people supporting her. Okay. And I mean she still has a lot of supporters. Don't get me wrong. But in terms of the opinions that people have, a lot more people favored her then as opposed to now. Maybe it changes. Maybe it changes as we get close, as the actual trial actually when the trial is underway. Maybe positions shift. But what I've seen so far, at least just in the previous or the motions we've been seeing and the hearings we've been seeing, there's a shift. Again, she still has a lot more supporters, but there's some people, or at least more, I'm seeing more people, I guess, being biased against her. But let's quickly get into this screenshot because I thought that it was interesting. And there was a Reddit as well. Maybe we get into the subreddit tomorrow because Karen Reed has a subreddit. So some person from 6 hours ago. Oh, that was 6 hours when I took this. So no, I actually took this yesterday. The screenshots from yesterday. Anyways, this individual, this was on CBS News Boston. They talked about, I suppose that's when they uncovered Canoni's ruling on the Collin case. And I'll talk about the Collin, the third party culprit issue. We'll talk about that briefly if we still have time. But this person, this is the caption. Let 6 me 23 reflect, whatever that means, okay? This person basically says that the evidence against Karen Reed paints a clear picture of her guilt. From the reconstruction of events to the forensic data retrieved from the SUV, every detail aligns with the actions leading to the tragic death of John O'Keefe. What is this? The reconstructionist has shown that the injuries on John's arm match a pedestrian strike by the SUV's taillight. debunking alternative theories such as a dog bite. Karen's own erratic behavior, including drunken voicemails and incoherent statements, further support her state of mind and intent during the incident. Moreover, the defense strategy of naming third party culprits without substantial evidence only serves as a distraction, harming innocent individuals and tarnishing their reputations. Justice demands accountability, and the truth lies in the evidence. Karen Reed's actions were deliberate and driven by rage. This trial isn't about distractions or blame shifting. It's about seeking justice for Joan O'Keefe and holding my screenshot cut off, so I have to move on to the next one, and holding Karen Reed accountable for her tragic and intentional actions. The jury's bias in this case is deeply concerning. How do they know? I don't know. Anyways, they said the jury, because I wanted to see the judge, but no, this says jury. It says the jury's bias in this case is deeply concerning as it threatens the integrity of the justice system. Regardless of the evidence presented, their prejudices seem to cloud their judgment, making it harder for the truth to prevail. I guess they're actually talking about the jury. I don't know how they're talking. Anyways, let's move on. This kind of taint undermines the years of work poured into uncovering the facts and holding the guilty accountable. Thankfully, Hank Brennan's involvement brings hope for clarity and justice. His commitment to presenting the truth despite the hurdles posed by biases or distractions is critical. Brennan's determination to highlighting the facts and dispel any false narratives ensures the truth will be heard, even if the verdict remains contentious. Justice must center on the victim, Joan O'Keefe, not on misguided loyalties or external pressures. Okay, that's what. And the reason why I took a screenshot of this is because I've seen a lot more of this sentiment going around this time around, which I had not seen the first time around. In any event, if we go back to just the facts themselves, okay? If we go back to the facts themselves, Brooklyn and I have been over probably the past week or so, maybe 2 weeks, maybe longer than that. But we've had this discussion back and forth about the third party culprit issue. Okay, when I read, because I read the reasoning for the first time on yesterday's live, right? I do not doubt. I'm sure if I went on Reddit right now, if I went on the Karen Reed subreddit, I'm pretty sure that a lot of people were upset about Canoni's ruling. Okay, her basically ruling that the defense cannot point to Colin Albert as a third party culprit, but they can go on to name the other. Are they Johns? Are they named Johns? Whatever. They have the same first name. With the I don't know. Hold on. I actually have no, I closed it because I did have the motion, not the motion, the ruling up here, but I closed it. I closed it when I was on this live because I have too many tabs open. In any event, if we take a look at that evidence, not the I guess if we do go back to the first trial, right? I've said it last night. I'm going to repeat it here again. Judge Canoni did Karen Reed a favor. They probably, I doubt defense interprets it that way, okay? But I'm going to interpret it that way for the reasons that I've previously stated. So the third party culprits that defense has alluded to, right? I cannot believe I'm drawing a blank. There's the first Albert. The first name has completely escaped me. The Albert that has the same name as Higgins, the first name, I know how it just escaped me. I cannot believe it escaped me. Anyways, the two individuals that can be named as third party culprits, sure. For them, I guess, jurors can, go through some hoops and say these people possibly could have, acted in concert. But to me, them, it's just not, it's not cogent. It's not coherent. It doesn't make sense. And the fact that they're not able to point to Colin Albert, that helps the defense. And the reason, again, they're not going to interpret that as a win because they wanted the option to point to all three. But Judge Canoni pretty much pointed out, the different issues, or rather the lack of substantial evidence to support, or what is this? The lack of substantial evidence in order for the defense to be able to point to Colin Albert as a third party culprit. The issue of him not being present at the time of John O'Keefe, not even at the time of his death, but when the kid was not there when John O'Keefe and Karen showed up. Okay, he wasn't there, and to me, okay, from a legal perspective, I did not like the approach that defense was taking, and the reason I don't like the approach, it's because it watered down and undermined any other potential third party culprits. Personally, defense, I would have focused on, I'd, I'd just have focused on Trooper Proctor. That's who I would have attacked. Uh, attack Proctor, basically attack Proctor every chance I got and move on from there. Because I'm trying to think about what the issues were when it came to Higgins. And man, I cannot believe that I forgot Big Albert's first name. That is just crazy. Yeah, that is so crazy. I'm drawing a blank. That is crazy. Olbeck says, I don't care about anything else. She couldn't have done that with her car. I take a different position. I take a different position. We'll see how Hank Brennan what is this, brings his evidence together. And again, it's a different trial. It's a different trial, so we don't exactly know how he's going to present the evidence. But I want to go to Reddit. Hopefully that subreddit is still there. There was a subreddit from, was it last week, the week before? Now I'm getting so distracted because I'm looking at this law firm subreddit and they're talking about termination. Okay, I'm a solo with 4 paralegals and an admin assistant doing trust and estates. I need to terminate and replace a paralegal who has been here for 15 years. He does okay work. But quality has declined over last year. I suspect why are you trying to fire them? Because they have health problems. Anyways, let's move on. We need to find the Karen Reed. I look at a lot of subreddits. I don't even know if I can find it. Let's just search for Karen Reed. Hold on. Karen Reed. I should have shared it with somebody so I could find it. Oh no, this is 11 years ago. This is something else. Somebody from 11 months ago was confident that Karen Reed was guilty. And here's the thing. We've had this discussion before. There's a difference between factual truth and substantive truth, okay? Right now, Old Bag is hung up on substantive truth. Hold on. There's no way I'm going to be able to find. It was a subreddit from like a few weeks ago. Was a subreddit over a few weeks ago. I cannot see it. I'm not going to be able to find it, but let's see what Old Bag, how many minutes? I have 5 minutes. So Old Bag says the witness in the one car said Karen was alone in the car when they passed her and they didn't see John on the lawn. And then Old Bag says, how did she do that with a car? No, really. I'd like to know how she could have. And then Old Bag, if a car can do that, explain that to me. She can be guilty. I don't care. There's too much reasonable doubt. We'll get into it. We'll break it down as the trial goes on. But I've said it before, whether somebody has engaged in the criminal conduct or not does not matter in a criminal court. Okay. And then this part, this is what I want to address. Obeg is like, how did she do that with a car? No, really, I don't like, or I'd like to know how she could have done it. I don't know, unless I read another message. Here's the thing. There have been trying to think, 2 or 3. There's one that stands out to me right now. But there have been a number of instances, right, where, and this is like real cases, okay? Real cases. There have been moments where I was presented with um, facts, underlying facts, and I for sure was like, nah, this doesn't sound right. There's no way, there's no way, there's no way. Um, there's a case, it was many years ago. There was a case. This man was charged with, it was not my case, and during the time I did prosecution work, so it doesn't really matter. But the defendant was charged with a murk. You guys already know what a murk is. Defendant was charged with a murk, but that man was old. Okay, I don't even know. This is like, ooh, this is many years removed. I don't even know if that person's alive. This was an old man, and uh, he was charged with murk. Um, and a lot of things did not make sense. A lot of things did not make sense because he would have had to move a body by himself. He was old. He looked really frail. Uh, Did he? I don't know. I guess he had some issues with ambulation. He had some issues with ambulation. If I remember correctly, there were stairs involved. There may have been a roof involved. And I had serious questions and serious doubt about this old man being able to carry a body with no help. I had real questions. I had real questions. And sure enough, there was the video. So uh I understand what you're saying, old bag, but I've had enough cases where facts were presented to me and I'm like, no freaking way, no way, I don't believe this. And sure enough, that actually happened to be the case. So consider that. Consider that. And Kelly and I have had discussions about, um, whether there's such a thing as committing a perfect crime. There's no such thing. The Some individuals, and I'm not talking about people that are wrongfully implicated, okay, because that actually does happen a lot. But for individuals, if we go to factual truth, for an individual that does in fact engage in the conduct that they are accused of, a lot of times law enforcement does not get the job done. There are a lot of times, I mean, don't involve the feds. The feds actually do their work. The feds do their work. But when it comes to state level law enforcement, they don't do the work. They just don't properly investigate. And the reason why they don't properly investigate is because of the plea dealing culture of criminal courts. That's just a fact. Most people are going to plead out, and because most people are going to plead out, uh, law enforcement does not always investigate thoroughly. Okay, so as far as uh, and again, if we have to talk about, you know, whether somebody did in fact engage in criminal conduct or not engage in criminal conduct, when we get to the verdict stage, and for people that do get acquitted, a lot of it really goes down to improper investigation, law enforcement. Again, maybe not being properly trained, maybe just being rookies and not knowing what to do. Because again, I'm just thinking about the Colin Albert case. And if we think about the two patrol officers that responded, they looked like they were still in high school, okay? And they did not know, or they did not understand that you cannot, even though this kid is in the back of the patrol car and you guys are having a discussion about video games and XYZ, you cannot ask them incriminating information, because if they do disclose that, it is going to be to be suppressed if you did not warn them or advise them of their Miranda rights. Anyways, that's enough rambling, folks. It's like 10:01. It's 10:01, and I need to get going. Okay, so Old Bag says yes, she will. Thank you for giving me that insight. Now I'm just saying, consider that possibility. There have been times, because even that old man, and that's why that old man sticks out to me, because man, my kid was in diapers. Was she even born? No, she was definitely in diapers at the time. And with that case, it still blows my mind, because when I read all of this, I was like, no, this man can hardly, he could hardly walk. There's no way he's going to carry a body up a flight of stairs and do this and do that, because I believe he also relied on a walker, if I'm not mistaken. And I was like, there is no way he did that. No way he could have done that. And sure enough, when I saw the surveillance, I was like, okay, let me shut up. Let me shut up, because apparently that, you just never know. Here's the thing. Even if we have to talk, because we can talk about, we can really talk about science in depth as this case progresses, okay? Even when it comes to medical doctors, right? When it comes to medical doctors and it comes to their testimonies is never stone cold. There's always an argument to be made, and a defense attorney is going to ask, isn't it possible that X, Y, and Z could have happened? And they're always going to say it's possible, because even though they have, again, if we go to Colin Griffith, because that's probably the case that's really fresh on my mind. If we go back to and I believe that doctor said that in Florida they don't have coroners. I think that's what he said, unless I'm mistaken. I believe that's what he said. But even when and that was a good witness, okay? That was a good witness for the prosecution. But even when he testified, he was pretty clear that, it's either way. It can go either way. As far, was it the injuries or something along those lines? But anyways, let's get going. So Benji said, Benji said, I enjoy the rambling as usual. So yeah, I do ramble. And we did not even get to the jury questionnaire, but it's up. We have it good to go tomorrow. Look, we're not done with Lori. Man, we're not done. How much time? No, I need to iron. I mean, it's only 8 minutes, but you guys know me. 8 minutes gonna turn to like 30 minutes. No, we'll leave it there. We might actually carry on from that. Okay, so Old Bag says the old man is a good example. Truly. Yeah, you just never know. Like, if you are not, I want to say, if you are not physically present, but even if you're physically present, there are moments where sometimes our recollections are off. We may remember, and I even have really good memory, but sometimes we remember things incorrectly. And there are times when trauma takes over and perception is off. There are a lot of things. And now that you talk about that, there's if you guys ever watch Soft White Underbelly, it's been a while since. Shout out to all the strippers, okay? But that's my type of content. So it's been a while since I watched Soft White Underbelly, but about must have been 2 or 3 years ago, I watched a really interesting episode. I mean, most of his content is really good. I like Leta, whatever his name is, I forgot his name, but I like a lot of his content. but I remember clearly. It's one of my many open tabs. I'm gonna have to find it because it's actually something I wanted to talk about. Hopefully, I do have time to you know, create. It's not going to be, a live. It will have to be a pre-recorded video. But on Soft White Underbelly, there's a man. I don't remember his name, but I remember exactly what it looked like, and I'm able to find the I'll be able to find the video just by looking at the old thumbnails. It's going to take me a while. I remember what this man looked like, and one of the distinguishing features of that video, this is going to sound really crazy, but while he was being interviewed, and this is me rambling, I'm talking about something else, but I'm going to make my point, and then I'm getting off the live. But what was interesting about that interview was the fact that while he was being interviewed, he was rolling up, okay? And I'm not talking about marijuana. He was rolling up. He was rolling up something. And the quality of the microphone was so good because you could literally hear the cracking of whatever it is that he was smoking. In any event, that's unrelated. So let's when it comes to Soft White Underbelly, this man had a very interesting background. He served a lot of time. He served a lot of time, and if I'm thinking back, it was somewhere in Florida. I want to say Liberty City area, but I might be mistaken on that. It was definitely Florida because after his interview, I actually went to go look his case up because I had to cross reference. I had to cross reference some information. In any event, his recollection, this is somebody that served time for a crime, okay? He served time for a crime. So you would think that the one person that actually knows what transpired would be him. But a lot of his information was off. I don't know if it was a lapse in memory or something was off. I don't know if he confused his victims, but something was off. That's just to say though, again, you don't always know. You don't always know. Stranger things have happened, and even if you may have witnessed whatever it is that you may have witnessed, your testimony might come off. Your testimony could also be questionable. There could be some credibility issues because we relay information. What we relay and what we observe is not always it's not that it's not always credible, but there are lapses there that cannot quite be explained. Maybe there's a psychological explanation. All right, so Benji also enjoys the Soft White Underbelly interviews. And then Oldbag says, I really appreciate this outlook. And so I appreciate you taking the time to explain things because you never know. we really do not know. We don't know. All right, folks, we will reconvene tomorrow, regular time, 8:30 p.m. Eastern time. And then you guys know that I have a new role. So I'll be serving as Lori Daybell's counsel. I'll be helping her. I'm standby counsel. I'll be helping her a little bit. And I'm going to try my very best to help her with cross-examination. Okay. I'm going to help her with cross-examination. And then we did not get a chance to go over the jury questionnaire in the Karen retrial. So we'll do that tomorrow, 8 p.m. Eastern time. And yeah, we'll reconvene tomorrow. All right, folks, that's enough rambling for one person. So I'll see you guys tomorrow. Have a fantastic Wednesday. All right. Shout out to Old Bag, Benji, and everybody else that tuned in.